Welcome to Lawyers on the Line. I'm Bob Falsani, a founding partner with the firm of Falsani, Balmer, Peterson, Quinn, and Beyer, and I'm this evening's moderator. Tonight's topic is criminal law. Crime and punishment is always clear-cut. The criminal justice system relies on judges, lawyers, and numerous other players in making sure defendants and victims are treated fairly while balancing the interests of society at large. So what should you know if you're involved in a criminal case? That's what the panelists are here to discuss tonight. We have Judge John DeSanto, who started practicing law about the same time I did. He's a district court judge here in Duluth, former chief prosecutor of the St. Louis County Criminal Division, and Dan Liu, the chief public defender for the 6th Judicial District, and Rebekka Stumme, who is a county attorney with the St. Louis County Attorney's Office. Judge DeSanto, Dan, and Rebekka, are you ready to take questions? If so, they'll be giving us a call at 218-788-2844. If that's long distance, they can call toll-free at 1-877-307-8762. Why don't I start out with a question I've got, all right?
Great.
I don't think the public knows a lot about how sentencing is done. You know, they know there's statutes that say if you do X, Y, Z, so many years in jail or whatever. But I know it's a lot more complicated than that. So why don't we start out with Judge DeSanto telling us a little bit about how sentencing is done.
Well, in Minnesota, since 1980, we've had what we call sentencing guidelines. Before that, we had indeterminate sentencing. We now have determinate sentencing. So you're sentenced based on the number of previous criminal convictions you had and the severity of the crime that you're being sentenced for.
Okay, so your track record comes into play here.
Very much so.
All right. And Dan, why don't you give us some examples, if you're representing somebody, what might be in a track record? Let's say there's a burglary charge, okay? What might they bring with them, and how would that affect what the sentence might be if you have to plead guilty or lose at trial?
On most felonies, the offense is ranked. So from 1 up to 11, and there are some offenses that are not on the sentencing guidelines grid. And it's a grid. So it's got an axis that takes the severity level of the offense. The other axis takes how many criminal history points you have. And it's a complicated system. It's going to require some math, but the typical burglary case that involves a residential burglary, assuming no one's present in the home, would have a severity level. It's ranked. You would take the person's criminal history score, and then you would follow it on a grid. A typical burglary would call for a presumed sentence of probation and no prison time. There would be a number of months that would be suspended in favor of probation.
So let's say it's your 9th burglary. Do you still get probation then?
Well, no. If it's your ninth burglary, and this is a complicated matrix. So, if it's your 9th burglary, and we have a decay factor. So this is not great for TV because this is higher math at times to figure this out. So there aren't clear-cut answers, but if it's your 9th burglary, you're likely facing a prison sentence unless, in Minnesota, judges have discretion to decide if they're going to deviate from the guidelines or go down. And there are a number of factors that a court would consider in determining whether or not a judge would sentence and not consider the guidelines.
Let's say that there's somebody that you think is bad, Rebekka. Okay,
Yes.
I mean, you don't like this guy, all right,
Okay.
or woman.
Don't like his behavior.
Yes.
Okay.
All right. And so you'd really like to max out the punishment here.
Okay.
What kind of things would come up in your advocacy to ask for more rather than less?
Okay. Well, there are a number of things that the prosecutor in that situation can do. First, when we charge the case or shortly thereafter, we can file what's known as a Blakely notice, which means that we're telling the court we think that this offense or this offender is so bad or has done something so horrible that we're asking you, Judge, to throw out that sentencing guidelines and to do something different. And obviously the prosecutor then would ask for a higher level of sentence.
Do you have to do that right away?
You have to do it and give the defense a fair opportunity to be prepared for that, to consider that issue when they're trying to defend a case. So there are some rules in place, but it's generally the court is going to tell us if this is a timely motion.
Give the public some examples in this. So what you'd say, okay, Judge, this person did X, Y, and Z,
Sure.
and they should get hammered.
To use your burglary example, let's say an offender has your 9 prior burglaries. Obviously, they're not getting the message and not changing their behavior, so that would be one factor. Plus, to tweak your example, somebody was present in the home and was injured. We have something called the zone of privacy, meaning that we in our homes should feel safe, and we're entitled to be safe in our homes. So when someone comes into our house and someone injures us, then we treat that more seriously. So that would be one example of when I would look at seeking a higher sentence.
And are these things listed, Judge, or is it just something that people dream up?
Well, it's a non-exclusive list within the sentencing guidelines, yes. Aggravating factors, which, by the way, now in order for a judge to impose them, they have to be determined by a jury typically,
Yep.
beyond a reasonable doubt. That's this Blakely case and the cases that came from that progeny, or from that original case that talks about the fact that I can't sentence as a judge without the aggravating factors like zone of privacy, particular cruelty against the victim, being actually proven like the elements of the crime itself beyond a reasonable doubt.
Now,
Right.
with the criminal history score and a certain kind of crime, all right, do you have some flexibility in the sentencing guidelines to start with? In other words, X months to Y months?
Yes, you do.
Okay. And you don't need to do anything super special for that?
No.
Prosecutor doesn't need anything special?
Right.
Okay.
There's a range.
All right.
Yes.
Now, we have this wonderful person, National Merit Scholar, likes to work with the poor and be helpful, and then they do their crime spree, okay? And otherwise, they've lived a wonderful life, and there's probably a good future here. The guidelines are going to call for 4 years in prison for whatever they do here. The compassionate Judge DeSanto gets the case, right?
Right.
But the naughty prosecutor doesn't like the person, their conduct, and really is pushing for the full sentence. And Mr. Liu is in there on the other side, okay? So,
He's arguing, and I'll let Dan speak for himself, but
Yeah.
for amenability to probation, remorsefulness, and the character of the person in essence. And then I have to make a decision after the hearing from the prosecution to the contrary of whether or not this does warrant a guideline sentence to prison or a departure downward, which would be a dispositional departure away onto probation, or maybe even a durational departure from the number of months to lesser number of months, even if it is in prison.
okay, Dan, have you had any success with compassionate results here in the right case? How has that gone?
No, we've had a lot of success with folks who are amenable to probation. We know in the criminal justice system there are 3 drivers that bring folks to court: chemicals, mental health issues, and uncontrolled anger that needs to be addressed. And these are 3 things that we can treat. We have great experts in the community, and we can treat these. And that's one of the significant factors when you look at what are mitigating factors. Person who's young, their age, their lack of criminal history, their ties to the community, serious and persistent mental illness. And we find in the courthouse, if we address some of the root causes, we can find a lot of success. So those are some of the most common mitigating factors.
How about the other way, Rebekka, going upward? Have you had luck doing that as well?
We have. To piggyback on what Judge DeSanto said, in order for the judge basically to sentence beyond that guidelines that we're talking about, The jury would have to separately find that those factors have been proven beyond a reasonable doubt, and then the judge has discretion to go up to the statutory maximum amount of years. And we have had success in certain cases. We certainly do not do this lightly. We try to be selective. We try to choose the cases deserving of that kind of extreme departure from the guidelines, but we have had success.
Now, is this jury thing, is this after somebody's pled or been found guilty?
Yes, they would initially be presumably found guilty by a jury of the counts, whatever counts they've been charged with, or maybe some and not all. And then the jury would be asked to come back, and I've done that with Judge DeSanto actually, and we would present additional information. Maybe it would be information about their prior record that the jury was not allowed to hear during the guilt or innocence phase, but now this is a relevant piece of information for the jury to consider. We would come back then and do another whole kind of mini trial.
Now, is the flip side true too? If you want to have a more lenient sentence, does a jury get involved in that? Or is it only when it's harsher?
It's typically only when it's harsher. In fact, maybe Dan or Rebekka can comment, but I can't even think of a time where the jury got involved in giving a lenient sentence. And it isn't the jury that determines the sentence. In Minnesota, it's not the jury is not a sentencing jury, as it is in some states. So it's just a matter of determining factors and whether they've been proven beyond a reasonable doubt, and that would be aggravating factors.
Juries only consider whether they're aggravating factors.
Yep.
Okay. So is it like a
Mitigating
special
factors
verdict
go to
form where they
judge.
answer a question, was so-and-so, does this aggravating factor apply?
Yes.
Is it something like
Yes.
that?
Yes.
Yes.
Okay,
That's
so
right.
it's not the sentence itself.
Right.
Correct.
Right.
And then
exactly.
so once that happens, it opens the door for you to give an enhanced sentence, and then I assume there's more argument between the prosecutor and the defense, right?
There's strong
Yes.
advocacy typically.
And the victim is then given an opportunity to make their wishes known in terms of what they feel an appropriate sentence is.
Right.
Now, what about plea bargaining? A lot of people think that that's a bad thing. Can we talk about that a little bit? Anybody want to say something?
Well, let me say just right off the top, and there's more to it than this, but without plea bargaining, which is common, the criminal justice system, at least locally here, would grind to a halt, because there'd be too many cases that have to go. I mean, I've heard over the years, I've been involved in the court system for 43 years, that there should be legislation, for instance, that does away with plea bargaining. Well, if that were to truly happen, it wouldn't be practical in dealing with efficiently with the criminal justice system.
Over 90% of our cases in the courthouse are resolved by plea bargains. Now, the critics of plea bargains would suggest that it gives prosecutors far too much power to charge a very severe offense to ultimately resolve the case at a less severe offense, leaving a person with this Hobson choice of, do you really want to take this risk? I'm proud to say that in northeastern Minnesota, there's a good tradition where our prosecutors work hard, I believe, to not overcharge a case. I'm not saying that doesn't happen, but the tradition is a solid tradition of you charge what you believe is appropriate. And for prosecutors that overcharge a case, there is that power of a jury trial to ultimately decide it.
Now, I think a lot of people think that, in the criminal system, it's so obvious whether somebody's guilty of X, Y, Z. Is that normally the case, or are there some gray things that, in terms of intent and proof, that make it uncertain the outcome sometimes?
Absolutely. I think that's one of the driving forces behind plea bargains sometimes. A case may come across my desk and look one way initially, and then as investigation develops, we find out information from the defense perspective. We have to consider all of those issues, and then things do become more gray sometimes. And we get the full picture. But we have an ethical obligation as prosecutors to charge only what we believe we can prove at trial. And so we do work very hard to make sure that happens, but we're all human beings. Sometimes witnesses disappear, victims change their mind, whatever comes up in a case, and we need to consider that. and figure out maybe the most reasonable and just way to resolve a case.
You know, in that vein too, Bob, I prosecuted for 35 years before my 6 years now on the bench as a judge, and I never had a case that I went to trial that I was absolutely certain of the verdict. There's still that uncertainty with the jury and how they view the evidence as it's coming forward. I had cases go to trial that I thought there was no way that I was going to prevail, albeit it had to go to trial, and got a guilty verdict, and just the opposite. Slammed what I thought were slam dunks, and they came back not guilty. So you just don't know when you go to trial. There is that uncertainty.
We see human beings at the most difficult moments of their lives, struggling with addiction, unmet mental health needs, and we see that in our complaining witnesses. We see it in defendants, and that leads to the uncertainty of what really happened.
All right. Now, is there ever a plea bargain that's done where the defense is, the prosecution is still likely got a really good case here. They're going to win this case in all probability, but there's some minimum sentencing if they're found guilty because there's a gun involved or whatever. And are there ever times when the prosecutor, as a matter of discretion, says, look, I'm going to cut a deal here because I don't think it really fits? Do you do that?
Of course we do. Yep. And there are a lot of there are offenses, particularly you mentioned guns, assaults with knives, repeat drug offenders, where mandatory minimum sentences are imposed or required to be imposed by the statute. And sometimes the state or certainly the bench has the discretion to move away from that, or to say, in this case, this doesn't fit, and the number of reasons that those factors could exist are innumerable. So that happens every day, and those are more issues or ways that judges have discretion, and sometimes the state does too.
All right. So is this something that you would say, monthly there might be a case where you'd actually give some ground where you thought you could convict of a higher crime, where you felt there were enough factors there where you provide some prosecutorial leniency in the plea bargain?
It's hard to put a number on it, but I would
I'm
say
not trying to get you
quite
fired.
often.
You understand? Yeah, because I got a question here, and it says they always hear about these repeat offenders, and why aren't they in jail the whole time? Why are they out repeating? Okay,
Right.
and what's the answer to that, Judge?
Well, one of the answers is, as sometimes it's argued, as draconian as our sentencing is in the sentencing guidelines, giving that there's still, for property crimes, and all crimes, even crimes, burglary are really not property crimes, but they're called that. They get lesser sentences than an assault against a person, or heaven forbid, a death case where someone's been killed, and they get out, and they often repeat if they're career criminals, and that's why they're not always in. There still is an end to their sentence, and in the property crimes there's a lower end than there is for the crimes against people that are hurt.
I've got a question here about chemical dependency, and people are saying, do judges take into account chemical dependency? And I think this is a good question to bring us into the specialty courts that are being developed in St. Louis County and probably throughout the state, huh?
Yes.
Who wants to take that?
Well, we're real fortunate. In northeastern Minnesota, we have no less than 6 specialty courts that address drug addiction, repeat DWI offenders, mental health. We have a court and a judge focused on veterans, and we have an emerging court that's working on downtown Duluth community offenses. And we're finding incredible success in our problem-solving courts, where prosecutors, defense lawyers, chemical treatment providers all sit at the table and begin finding solutions for really what's the root that brings the person back to our courthouse day in and day out. We recognize
is this sort of like kumbaya, touchy-feely stuff then? Or?
No, many of these problem-solving courts use jail, but they're following some of the best research that says jails don't solve problems. following some of the best research that says jail under 7 days can change behavior, but over 7 days says it doesn't do a thing and causes harm, especially with someone struggling with addiction. And it understands the addiction.
So how do they run these courts, Judge? What is it like?
There is a team. There's a judge assigned. For instance, in South St. Louis County, the drug court judge is Judge Dave Johnson. I happen to be the backup judge to him when there's a need for me to fill in for him. And with probation officers, law enforcement, prosecutor, defense, all teaming specific drug cases. And when you say that it is a touchy-feely kumbaya stuff, actually, drug court is what I've always believed and seen and witnessed is actually more severe. It's stricter than standard probation because there's going to be immediate consequences when you relapse. And with drugs, relapse is almost inevitable. And so there's immediate consequences, less than 7 days, like Dan says, at the jail, but you're going to go to jail when you relapse. And
Now,
there's that fear.
Is this after a plea or a sentence?
In South St. Louis County, we're working toward, I think, it can be even before a plea, before guilt is determined. On North St. Louis County Drug Court is an after conviction drug court.
So do you meet then like once a month or once a week or something?
Once a week.
Once a week.
Once a week.
So the judge is almost like a probation officer a little bit.
In a
huh?
sense, that's true.
This is quite a change for a career prosecutor here, isn't it?
It is. Well, although as a prosecutor, I was originally the prosecutor component on the drug court when it started in Duluth in 2002 as well.
Would you like to sing now then, Judge?
You don't want me to sing.
Okay. So what do you think of this, Rebekka? Is this working, this drug court thing?
I think it's working. I think we've got research even within our own courthouse that says that it can work. But I do want you to know, Bob, that it's not a 100% success rate. There are people who just fail out of these courts. And I like to think of it as you can lead a horse to water, but you can't make them drink. We can put every single resource in front of somebody who's struggling with chemicals, and they're just not going to change. They're not incentivized to change. And there are times when drug court or DWI court throws up their hands and says, we just can't work with this person anymore, and they do end up going to prison. So that is the kind of the flip side of drug court, is that we do have that consequence available, and that's a good thing.
What about the meth people? That I've seen this
Bob,
data on meth that's like
Let me put this into context. In our problem-solving courts
Yeah.
in northeastern Minnesota, we have a 70 to 80% success rate in graduation.
Wow.
You find any program that deals with mental illness and chemicals that has that success, and I'm ready to have the discussion. But the success in problem-solving courts are quite remarkable.
I mean, I went to the seminar on addiction, and we're talking about how meth is somewhere up in the ceiling, and alcohol is here, and cigarettes are here, or whatever. But and is there success with the meth people too?
There is.
There.
And
is.
heroin is also
And
very
heroin.
difficult.
Heroin's even
More difficult to treat.
And the prescription medication. So a lot of success.
Here's a question I knew we were going to get. How difficult is it to get a record expunged?
Well,
Go ahead.
actually, there were some legislative changes just within the last year that makes it less difficult for lower level crimes. For misdemeanors, you don't even under some circumstances don't even have to go to court. It can be it's done. But having said that, the expungement might not affect all records everywhere, and I'll let Dan talk about that a little bit too.
General rules: 2 years after you're done with your sentence on a misdemeanor, 5 years after a felony. It's a fairly selective list, but it opens up the list, and it's really been defined as the second chance legislation, so it's become a lot easier.
So, for example, let's say you had a burglary charge, okay? Is that something that's expungible?
It is expungable.
Okay.
After
And
so
then-
much time of crime-free behavior.
And then,
and
so
living.
once it's expunged, can you vote again and get a gun and all that kind of thing then?
The gun thing has some issues to it, especially under federal law. Some are lifetime bans on possession of firearms, but there is ability to have a second chance with a clean record. It's become better and easier, if you will.
It's mostly opened the doors to housing, employment, which are real keys to folks being successful.
One of the things that I've run into doing civil work is how criminal records impact people's lives in other ways. And there's this Kerry Koskinen law, I think it was, where, when it was passed, if you had a job, say, where you had access to people at a hotel or a college or whatever, once it was passed, they would look back in people's records and say, oh, this person had a certain felony back, 20 years ago. They have, and the employer would have to terminate them. So I think one of the things is that people don't even realize when they have a felony on their record, all of these things across their lives that are impacted. Just certain employment opportunities and so forth and so on. So anyway, I guess we'll have to move on. We had plenty of other things we could have talked about tonight.
Sure.
Okay.
That's all we have time for. Remember, you can watch our show again online at www.wdse.org or www.duluthtrilelawyers.com. Please join us again next week when we'll be talking about wills and estates. And I'd like to thank the panelists tonight for their expertise. This has been terrific. We could have gone on forever. I'm Bob Falsani. Good night.